Alright, so according to Nizamie and Cited, the National Library of Medicine, music is defined as vocal and or instrumental sounds combined in such a way as to produce beauty of form, harmony, and expression of emotion is music. I'd like to emphasize expression of emotion. Recently, there have been reports of offensive music filed here at the warehouse. Team, stop playing offensive music out loud.
Hold on, what's offensive music?
Hold questions to the answer. Offensive music played out loud negatively represents the company, alienates and oppresses fellow employees, and creates a hostile work environment. Offensive music has been played out loud specifically on the receiving dock, but has been noted elsewhere. This is music that is derogatory towards specific genders. This is also music that describes acts of violence. This represents our company in a negative way when we receive visits from vendors, truck drivers, potential customers, and such like that. This has caused other people to feel alienated and hard to come into work and focus on the tasks that they have to do. I've received several reports over the course of a couple of weeks that individuals are offended and feel embarrassed and ashamed by the offensive music being played out loud when visitors enter the building. The offensive music creates feelings of uneasiness among employees. All concerns with these types of feelings are taken very seriously by the employer. This is contributing to a hostile work environment, and it causes friction in the workplace that makes it harder for us to function as a team due to people feeling alienated and not being able to focus and being forced to listen to such things. And if it continues, it will cause animosity in the workplace and create a hostile work environment that's not fair for employees and is not a value of reach. So, my plan of action, when we play music out loud, this is what I suggest. Ask the question before it gets played, will this be offensive? If you have to think about it, don't play it. Be honest with each other and with management. If it's offensive, we need to address it. We can create a clean playlist to avoid potential grievances. And we have to report these non-compliances when if things still continue to happen in this way with management so that it can be addressed. If we stop playing offensive music out loud at work, it can work if we make it work. But it's going to take teamwork, and we need to communicate and use teamwork to determine what is offensive. Creation of clean playlists over time will enable us to create a culture where we have a harmonious work environment. So what happens if we do? If we do this, if we stop playing the offensive music out loud at work, we can keep playing music out loud. We can continue to have that music at work, and we can grow as a team in our understanding of each other and get to know each other through the culture. But what happens if we don't? On February 9, 2023, 7 females and 1 male met to reopen the lawsuit of Sharp versus SNS Activewear. So, in 2020, these same individuals filed a lawsuit with SNS Activewear at a warehouse in Nevada, where offensive music was said to be played out loud. Quote unquote, sexually graphic, violently misogynistic music throughout its warehouse. The company will have to take action against individuals that continue to play offensive music out loud to protect themselves and other employees and to produce a harmonious work environment. And in this particular instance, right, the court case stated, the lawsuit stated that the management continued to allow the music to be played. In 2020, the lawsuit was turned down. But in 2023, it was reopened. The senior United States Circuit Court judge of the United States Court of Appeals for the Ninth Circuit, Margaret McKeown, in her written opinion of the Sharp versus SNS case on August 7, 2023, states, music with sexually derogatory and violent content played constantly and publicly throughout the workplace can foster a hostile or abusive environment and thus constitute discrimination because of sex. McKeown goes on to say, first, harassment, whether auditory or visual, need not be directly targeted at a particular plaintiff in order to pollute a workplace and give rise to a Title VII claim. Second, the challenged conduct's offensiveness to multiple genders is not a certain bar to stating a Title VII claim. So it doesn't even have to go towards one gender or the other. Title VII, what it's referring to is Title VII of the Civil Rights Act of 1964. This act protects employees from harassment by holding employers liable for any unaddressed violations. And it states that employees can establish a violation of the act by proving that discrimination based on sex has created a hostile or abusive work environment, which were literally the exact words of Judge McKeown in her opinion that she filed for the reopening of the court case of the lawsuit against SNS Activewear, which is that warehouse in Nevada. Very eerily similar to this. In summary, all employees should stop playing offensive music out loud in the workplace immediately. REACH will do its due diligence to address these complaints to remain in compliance with Title VII of the Civil Rights Act of 1964. It alienates employees, creates a hostile work environment, and poorly represents the company with a negative image to potential vendors and other people that associate business with REACH. Please do not play offensive music out loud in the workplace.